Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And this is episode 23 of Constitutional Law. Today, we're focusing intently on the Eighth Amendment.
We are AI bots brought to life by the magic of AI and, importantly, Angela's constitutional law notes.
Exactly. And those notes are the foundation for today. So you, our listener, are diving deep into the Eighth Amendment with us. It's a really crucial part of constitutional law for the bar exam, obviously.
It really is. And our materials, everything we're discussing, it comes directly from Angela's comprehensive law school notes.
And Angela, well, she's a current law student at George Mason University. She also holds a graduate degree from the University of Law in London, UK. So she brings great perspective.
Absolutely. Her insights and outlines, they really form the backbone of our discussion today. They're incredibly detailed.
And if you find this helpful and need to reach out to Angela, maybe with feedback or a question about the notes, you can email her. The address is podcast@studyforthebarinyourcar.com.
Yeah, she welcomes that. And also, Angela works as a freelance remote law clerk. So if you happen to be an attorney, or maybe you know one who needs some help.
Right, like with legal research, writing motions, that kind of thing.
Exactly those tasks. You can connect with her for her professional services by emailing hello@legalwriterandlawclerk.com.
She's a fantastic resource, and you'll hear that quality reflected in the notes we're about to unpack today.
Okay, so let's set the stage for the Eighth Amendment. It states, and it's quite concise, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Seems straightforward, right? Bail, fines, punishment. But like everything for the bar exam, the real substance is in the details, the history, the cases.
Precisely. We need to trace its origins, see how it's applied today, look at the key cases, the controversies. It's not just about reciting the text.
So break down each phrase. Excessive bail first, then excessive fines, and finally, cruel and unusual punishments.
Yeah, giving you the context, the nuances, everything you need to really nail any bar question on the Eighth Amendment.
Okay, let's get into it. Part 2, the lessons.
So, starting, as you said, with the text itself, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
And where does this idea even come from? It feels fundamental, but it has roots, right?
Deep roots. Angela's notes trace it back to English law, specifically the Glorious Revolution period, 1688-89.
Okay, the Glorious Revolution. How did that influence this?
Well, that whole period was about pushing back against governmental power, limiting the monarchy. It really set the stage for codifying rights against abuses.
Ah, so it led to specific documents.
Exactly. The English Declaration of Rights and then the English Bill of Rights, specifically Section 10 of the Bill of Rights. That's the key precursor.
And Section 10 said what?
It explicitly prohibited excessive bail, excessive fines, and cruel and unusual punishments. Almost word for word what ended up in our Eighth Amendment.
Wow. So it was a direct borrowing. Was there a specific reason, like were punishments particularly be bad back then?
Oh, absolutely. The historical context includes some truly horrific examples. Angela's notes mention Titus Oates.
Titus Oates, what happened to him?
He was subjected to just brutal punishments. Flogged nearly to death multiple times, pilloried repeatedly, life imprisonment. His sentence was seen as so outrageously disproportionate, so cruel, it became a symbol of the very abuses the English Bill of Rights aimed to prevent.
Okay, so that context really highlights why they felt the need to explicitly forbid cruel and unusual punishments and excessive penalties.
Precisely. It wasn't abstract. It was a reaction to real, severe governmental overreach.
And then this principle crossed the Atlantic.
Right. It was incorporated into our Bill of Rights, ratified in 1791. But even before that, the idea was circulating in the colonies.
Like in state constitutions.
Yes. Angela points to the Virginia Declaration of Rights from 1776. Used very similar language, calling it a linguistic forerunner. It shows these concepts were already taking root in American legal thought.
So the overarching principle here, across all three clauses, bail, fines, punishment, it's about preventing the government from going too far, right?
Exactly. It's a fundamental prohibition against excessive governmental actions. Keeping state power within reasonable, humane bounds. That's the core idea.
Okay, let's zoom in on that first clause. Excessive bail shall not be required. What does that actually mean in practice? Is there a right to bail?
That's a key point. The amendment doesn't explicitly guarantee bail in every single case. It doesn't say bail must be offered.
Uh-huh.
What it does say is that if bail is set, it can't be excessive. So it implies bail should generally be available, but it regulates the amount, not necessarily the availability itself.
And this applies to the states, too, not just the federal government.
Yes, and that's crucial for the bar. Through incorporation via the 14th Amendment's Due Process Clause, Angela's notes highlight the McDonald v. City of Chicago case from 2010.
Wasn't that a Second Amendment case?
Primarily, yes. But in dicta, the court lifted the excessive bail clause among the incorporated rights. That means states and local governments are also bound by this prohibition against excessive bail. It emphasizes its fundamental nature.
Okay, so bail can't be excessive if it's set, but can bail be denied altogether? I thought the point was to ensure appearance at trial.
That used to be the main thinking, but United States v. Salerno in 1987 really changed the landscape there.
Salerno, what did that case establish?
It upheld the Bail Reform Act of 1984. That act allowed for preventive detention, holding someone without bail, not just based on flight risk, but if they posed a danger to the community.
So public safety is a valid reason to deny bail.
According to Salerno, yes. The court explicitly said the excessive bail clause says nothing about whether bail shall be available at all. It only restricts the amount when bail is granted.
So the government can detain someone pre-trial for reasons other than flight risk, like community safety.
Correct, as long as there's due process. Salerno makes it clear that protecting the community is a legitimate governmental interest that can justify denying bail in certain situations. That's a critical distinction for bar questions.
All right. But when bail is set, how do we know if it's excessive? Is there a dollar amount?
No fixed amount. The standard comes from Stack v. Boyle back in 1951. That's your foundational case for defining excessiveness.
And Stack v. Boyle says,
bail is excessive if it's set higher than an amount reasonably calculated to ensure the defendant's appearance at trial. That's the sole permissible purpose considered in Stack assuring appearance. It cannot be used as a punishment before trial.
Reasonably calculated. How do courts figure that out?
It requires an individualized assessment. This is key. Courts have to look at several factors. Angela's notes list them. The nature and circumstances of the specific offense charged, the weight of the evidence against the accused, the defendant's financial ability, can they actually pay it without undue hardship, and the defendant's character, like their ties to the community, past behavior, flight risk history.
So it has to be tailored to the individual defendant and their situation.
Exactly. No one-size-fits-all, which leads to issues with bail schedules.
Right, those lists where certain crimes have preset bail amounts. How do they fit with Stack v. Boyle?
They can be problematic. Angela's notes caution that while bail schedules offer administrative convenience, they risk violating the Eighth Amendment if they're applied rigidly without that individualized assessment.
So if someone's held on a bail schedule amount,
they must have a prompt opportunity for a judge to consider their specific circumstances, those Stack factors, to ensure the amount isn't excessive for them. Otherwise, the schedule might just be punitive.
Okay, that makes sense. Now, Angela's notes mention something about non-justiciability and procedural harmlessness for bail clause violations. That sounds complicated.
It's a bit nuanced, yeah. The idea, as Angela outlines it, is that even if bail was set unconstitutionally high, that violation alone might not automatically lead to overturning a later conviction.
Why not? Isn't it a constitutional violation?
It is, but the appellate court might see it as procedurally harmless if the subsequent trial itself was fair and didn't suffer from other constitutional errors. The focus shifts to the fairness of the conviction process.
So you wouldn't necessarily get an automatic reversal just because bail was too high?
Not necessarily, according to the conventional view, Angela notes. The defendant typically doesn't bear the burden of proving prejudice from the bail violation itself in this context. It's a tricky point about remedies.
Good to know for essay structure, maybe. Okay, let's move to the second clause. Nor excessive fines imposed.
Right, the excessive fines clause. This prohibits the government from imposing financial penalties that are, grossly disproportionate to the offense committed.
And this also comes from that English history.
Yes, same source. Section 10 of the English Bill of Rights. It shows that long-standing concern about the government using financial penalties in an abusive or overly harsh way.
What kind of fines are we talking about? Criminal fines only?
Not necessarily. The Supreme Court has held it applies to civil forfeitures too, if they're at least partly punitive. The key is whether the financial penalty is disproportionate to the wrongdoing.
So the fine has to serve a legitimate purpose, like punishment or deterrence.
Exactly. Deterrence, retribution, compensating victims, legitimate goals. But the fine shouldn't be so large that it becomes unduly punitive or essentially confiscatory, meaning it strips someone of their livelihood or property way out of proportion to the offense.
Okay, that seems fairly clear. Now for the big one. Nor cruel and unusual punishments inflicted. This feels like the most debated part.
It absolutely is. And the key concept here is the idea of evolving standards of decency.
Evolving standards, meaning what was okay in 1791 isn't necessarily okay now.
Precisely. The Supreme Court doesn't interpret cruel and unusual based solely on historical practices from the time the amendment was written. Instead, they look to the evolving standards of decency that mark the progress of a maturing society.
So our understanding of what's cruel and unusual can change over time.
Yes, it's a dynamic standard reflecting societal values, moral judgments, and even scientific understanding.
And a major principle that comes out of this is proportionality. Right.
Huge principle. The punishment must be proportionate to the crime. This applies not just to the type of punishment, like whether a method of execution is acceptable, but also to the length or severity of the sentence.
So you couldn't sentence someone to life without parole for, say, petty theft.
That would likely be considered grossly disproportionate under the Eighth Amendment. The punishment has to fit the crime in a fundamental sense.
How does this apply in the context of the death penalty? That's always a major Eighth Amendment issue.
It is. Angela's notes mention Bucklew v. Forsyth, which dealt with the method of execution. The court asks if the method poses an objectively intolerable risk of harm beyond what's necessary to carry out the death sentence.
So it's about avoiding unnecessary suffering in the method itself.
Right. And more broadly, in capital cases, the court uses a specific two-part inquiry to see if the death penalty is permissible in a given context or for a certain category of offender.
Okay, what's that two-part inquiry?
First, the court looks for objective indicia of society's standards. This means looking at state laws, jury decisions, actual practice. Basically, is there a national consensus against applying the death penalty in this specific situation?
A national consensus. Does that mean every state has to agree?
No, not unanimity. More like a clear trend or general agreement expressed through legislative action and practice across the country.
Okay, so first, check for consensus. What's the second part?
If a consensus is found, the court then applies its own independent judgment. It weighs the penological justifications for the punishment, like retribution and deterrence, against the severity of the penalty and the characteristics of the crime and the offender.
And this framework has led to limits on the death penalty for certain groups.
Exactly. Angela's notes highlight juvenile offenders. The court has found a consensus, informed by evolving standards, against imposing the death penalty or mandatory life without parole on individuals who committed crimes as minors.
Why? Because of their age?
Yes, based on their reduced culpability due to developmental immaturity, their greater capacity for change, things like that. It reflects those evolving standards.
And similarly for offenders with intellectual disabilities?
Correct. The Eighth Amendment also prohibits executing individuals with intellectual disabilities, again based on evolving standards, recognizing their reduced culpability and potential difficulties in their defense.
So the cruel and unusual analysis is very sensitive to the specific offender and societal views.
Very much so. But it doesn't stop at sentencing. The Eighth Amendment also governs what happens inside prison.
Prison conditions, like overcrowding or lack of medical care.
Yes. This is a huge area of Eighth Amendment litigation.
Mm-hmm.
Prison officials have a duty to provide humane conditions and protect inmates from harm. Failure to do so, especially with deliberate indifference, can violate the Eighth Amendment.
Angela's notes mention a case, Talley v. Stevens, from 1965.
Right, an early example. It involved corporal punishment, whipping prisoners with a strap.
Was whipping itself declared unconstitutional?
Not per se in that specific case, but the way it was done was found constitutionally defective. There were no clear standards, no safeguards against arbitrary or excessive application.
So the lack of process and standards made it cruel and unusual in practice?
Essentially, yes. The court stopped the practice until the prison developed a plan with proper safeguards. It showed the federal courts would scrutinize prison practices under the Eighth Amendment.
And that applies today to things like excessive force by guards or dangerously unsafe conditions.
Absolutely. Deliberate indifference to serious medical needs, failure to protect inmates from violence, grossly inadequate sanitation or food. These can all be grounds for an Eighth Amendment claim regarding prison conditions.
Okay. Now, let's shift to a really complex and current issue mentioned in Angela's notes, applying the Eighth Amendment to homelessness. How can homelessness involve cruel and unusual punishment?
It's about punishing status or involuntary actions tied to that status. Angela's notes point out that many local laws criminalize basic survival activities for people who are homeless.
Like what kind of activities?
Things like sleeping or camping in public when there's no shelter space, loitering, sometimes even sitting or lying down in certain areas, panhandling. The notes mention examples from specific city codes like Hartford, Manchester, Middletown.
So if someone literally has nowhere else to go and they sleep in a park, they could be arrested.
Under some ordinances, yes. And the argument is that this punishes them for conduct that is an unavoidable consequence of their status as homeless, especially if shelter is unavailable.
How does that connect to cruel and unusual?
The argument, based on cases interpreting the Eighth Amendment and related principles, is that punishing someone for an involuntary status or unavoidable life-sustaining actions constitutes cruel and unusual punishment. It's like punishing someone for being sick.
And these laws create other problems too, right?
Definitely. Angela's notes highlight that this creates a cycle. Homelessness leads to tickets or arrest, which leads to fines they can't pay, maybe incarceration, which then creates even more barriers to getting housing or a job. It makes escaping homelessness harder.
The notes also mention police officers sometimes see the futility.
Yeah, quoting officers saying things like, "An arrest, quite frankly, doesn't fix the problem," or "We are never going to arrest our way out of this issue." It points to the practical difficulties alongside the legal questions.
And there's the disparate impact aspect too.
Yes, the notes state these laws disproportionately affect already vulnerable groups, people of color, transgender individuals, people with disabilities, citing data showing higher arrest rates for African Americans in some Connecticut cities, for example.
This ties into a policy debate. Angela's notes cover the shift away from housing first. The notes mention President Trump's executive order.
Right. And we need to be careful here, just reporting what Angela's notes describe based on various sources. The notes frame this executive order as representing a stark reversal from the long-standing housing first approach.
Okay, so first, what is the housing first approach, according to the notes?
It prioritized getting people into stable housing first, usually with support services like case management, but without preconditions like requiring sobriety or treatment enrollment up front.
The idea being stability comes first.
Yes. The notes mention evidence, like a review of 26 studies suggesting housing first significantly decreased homelessness and improved health outcomes, reducing costly emergency care. It was expanded under Obama and Biden, viewing housing as basic health need.
And the approach described in the notes attributed to President Trump.
Again, based on Angela's notes compiling various reports and policy documents, it's described as a new approach, focusing on potentially forcibly moving people into large camps, mandating treatment as a prerequisite for housing, and using a more punitive approach with fines or jail time.
So a shift towards conditions and consequences.
That's how the notes characterize it, also mentioning prioritizing funding for states that treat homelessness as a crime and potentially cutting funding for things like harm reduction programs. The rationale cited is a belief that housing first might enable addiction, favoring mandated treatment first.
And what are the potential legal challenges to this approach, as outlined in the notes?
Several. The big one we've been discussing is the Eighth Amendment, arguing that criminalizing the status of being homeless or unavoidable acts like sleeping in public is cruel and unusual punishment. As one quote puts it, "When they make all your activities illegal, then there's nowhere for you to go."
Beyond the Eighth Amendment.
Potential civil liberties violations. Freedom of movement is a big one. Loitering laws or restrictions on being in public spaces could clash with this fundamental right recognized by the Supreme Court and international treaties the U.S. has ratified.
What else?
Free speech issues with laws banning panhandling. Privacy concerns when people are forced to perform basic life activities in public. And due process concerns penalizing status or necessary conduct without adequate alternatives or procedural safeguards could violate due process, especially when fundamental liberty interests are at stake.
So critics cited in the notes argue this approach is constitutionally questionable, besides being potentially ineffective or unethical.
Yes, the notes convey arguments that it's unethical, ineffective, and illegal, potentially worsening homelessness and misdirecting resources away from housing and healthcare, which they argue are the actual needs.
Okay, that's a complex intersection. How does all this tie back to broader constitutional principles like due process and liberty interests?
Fundamentally, the Eighth Amendment protects against excessive government actions that constitute a deprivation of liberty without justification or proper process.
Deprivation of liberty. Like being incarcerated, obviously.
Yes, but it can be broader. It's about losing a significant freedom protected by the Constitution or laws. excessive bail, fines, cruel punishments, they all infringe on liberty interests.
And the due process connection?
Well, you generally need notice and a hearing before the government can impose a significant deprivation, like institutionalizing someone. Angela's notes use that as an example. This principle becomes relevant when discussing things like mandated treatment or confinement related to homelessness, or the proper procedural safeguards in place to protect liberty interests.
So the Eighth Amendment is really one specific protection for fundamental liberty interests against governmental overreach and inhumane treatment.
That's a great way to put it. That core principle guides courts as they apply the amendment to new situations, ensuring it remains relevant while protecting those basic rights. Understanding that underlying theme is vital for the bar.
Well, that was a deep dive. You should now have a much more solid understanding of the Eighth Amendment, covering its history, the key clauses, major cases, and even current controversies like its application to homelessness. All thanks to Angela's incredible constitutional law notes.
They really are comprehensive. Her outlines allowed us to explore this in such detail, hitting the points you need for the bar.
Okay, before we wrap up this podcast, we absolutely need to cover some important housekeeping items and disclaimers. This is for your benefit, our dedicated bar exam studiers.
Right, pay attention to this part. First off, please remember, Angela is a law student, just like many of you listening.
Yeah, she's brilliant, but she's not an expert in the sense of being a licensed attorney who's passed the bar yet. These notes are her personal academic work product, shared to help you learn.
Second, and this is critical, neither Angela nor we AI bots, nor this podcast, is giving legal advice. Absolutely none of this content should be taken as legal advice.
Think of us as a study aid, maybe a supplement, but definitely not a shortcut. AI isn't a substitute for doing the hard work of studying for the bar.
Third, related to that, this podcast should supplement your learning. It really shouldn't be the only way you're studying. Use it alongside your bar prep courses, your practice questions, your outlines.
Definitely. It's an addition, hopefully a powerful one, but just one piece of your overall study plan.
Fourth, perfection isn't guaranteed. Even AI isn't always correct. Sometimes we might make mistakes in how we explain things.
And while Angela does her absolute best to ensure her notes are accurate and fixes any errors she finds, even diligent law students can sometimes make mistakes. We try our best to correct any wrong information, but always cross-reference.
Good advice. Always double-check against reliable sources. Fifth, this podcast episode and the whole series. It's an academic, non-commercial project by Angela. It's purely for educational purposes, aimed at helping you on your bar exam journey.
And finally, number 6, the practical tip. When you're driving, please, the most important thing is to be safe on the road. Seriously. Don't cause a tort while listening to constitutional law. Otherwise, you might face a criminal prosecution.
And then you get to enjoy your own Sixth Amendment right to a speedy and public trial. Let's try to avoid that.
Agreed. Okay, quick reminder on contacting Angela.
Right. For podcast feedback, email podcast@studyforthebarinyourcar.com.
And for attorneys needing research or writing help, her freelance law clerk email is hello@legalwriterandlawclerk.com.
All right, as is our tradition, before we officially sign off, we have a cheesy Eighth Amendment joke for you. You ready?
Lay it on me.
Why did the judge bring a ladder to the bail hearing?
I don't know. Why?
Because he heard the defendant had to clear a high hurdle.
Wow. That joke was so bad, it was cruel and unusual punishment just listening to it. I aim to please. Okay, one final thought to leave you with. Considering those evolving standards of decency, what current practice or punishment, maybe widely accepted today, might future generations look back on and say, wow, that was cruel and unusual under their Eighth Amendment? Something to ponder about the future trajectory of the law.
Definitely food for thought.
This is Maude and Claude, your AI hosts, signing off.
We'll see you on the next podcast, where we dive into the Ninth Amendment, addressing those tricky, unenumerated rights.
Thanks for listening.
Ciao, Bella.